Welcome, everyone, to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with two attorneys I work with, Jennifer Walrath and Doug Plass. Today, we're talking about EEOC trends and an update on what we're seeing from the EEOC over the past month or so. For those of you who don't know, and I'm guessing most of you do, but the EEOC is the Equal Employment Opportunity Commission, and that is the federal agency that oversees enforcement of our different federal anti-discrimination statutes. So, fascinating. Really, since the beginning of the year, we have seen more fascinating and unexpected trends from the EEOC than I think we could all safely say we've ever seen in the time that we've been practicing as attorneys. And when we're thinking about EEOC trends and changes, our go-to source is the EEOC directly. And I know that if you've listened to some of our prior podcasts, you've heard us talk about the EEOC press releases and the EEOC emails that you can get on that tell you what type of cases the EEOC is prosecuting, what their enforcement priorities are, what kind of trainings they're holding. And those same emails also have a number of media press releases that tell you about what type of initiatives and priorities the EEOC has. And so that's our go-to source when we're thinking about what is the EEOC up to right now. We're looking at what the EEOC is sending out. And so that's what we're going to talk about today, as a couple of different things that the EEOC has sent out over the last 30 days or so. And some of this you'll find familiar because on a prior podcast, we were talking about the executive orders that have been issued by the Trump administration since January. And those executive orders directly tie to what the EEOC enforcement priorities are right now. So I'm going to jump in and talk about one of those and get Jen and Doug's input on what they think it means, their thoughts, maybe some guidance for employers, and really hopefully practical takeaways that you can take back to the workplace in regard to some of these trends and changes that we're seeing. So the first executive order that the EEOC has been citing to and talking about is Executive Order 14168, and it's entitled Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the federal government. So what does that mean and how does that impact the EEOC? Well, on January 28th, the EEOC issued a press release and it indicated that the agency is rolling back the Biden administration's gender identity agenda. And it also indicated that prior EEOC harassment guidance, which you've heard us talk about, is flawed under the eyes of the EEOC as it is currently operating. And so we want to talk a little bit about what that means in terms of employers trying to be compliant and to have a workplace that tracks with Title VII and state law as well. So, Jen, Doug, what do you guys think in regard to this pronouncement by the EEOC that the agency is rolling back the Biden administration's gender identity agenda?
Well, I think the first place to start is this is kind of signaling what they want to do, what the administration wants to do. But right now we're in a situation where there is no quorum at the EEOC. We have an acting chair who has made a bunch of statements here about what they want to do, but at the same time acknowledges they cannot unilaterally remove the guidance that's already there in place. So we're seeing I think we can expect that once there's a quorum restored, we see some action on this, and that we see probably that they make more action. I mean, they've removed the pronoun app that allows for the EEOC employees to identify what pronouns they go by. They've removed the X gender marker in the intake process. If you go to file a claim of discrimination, they removed the choice to use the mix title rather than Mr. or Ms. As a list of prefix options. So they've done some things, but the guidance itself is a bit in conflict with that. So I don't know. I think it creates more questions than it answers, frankly.
Yeah, I agree with Doug, and I apologize. I'm getting over a little bit of a bronchitis, so my voice is a little bit odd today. But the thing I was going to add is, I think the other kind of backstop here, if you will, is the Supreme Court's Bostock decision in 2020, I believe, which did say that it is against the law of Title VII to discriminate against someone because of their sexual orientation or their gender identity. And it has been interesting because a lot of the executive orders and messaging that we have seen come out of this administration have also emphasized that what they are doing is consistent with Title VII and the law of Title VII as it exists. So I think it will be interesting to see what the scope of changes coming down the pipes look like and how far they go, because that definitely is the law currently, according to the Supreme Court. Things could change, but that is, so far, all indications are that whatever they're doing will be consistent with that decision.
Yeah. It is important to add, along the lines of what Jennifer's saying, that even though we have seen a number of these executive orders, we do know that they certainly don't change the case law that is in place right now. So we do still have, like Jennifer said, the Bostock case, United States Supreme Court authority, and really all the other case law that's out there. Just because we have these executive orders, those cases and that binding legal authority has not changed. So that is an important thing for employers to think about. The EEOC harassment guidance that came out last year addressed a couple of things that to me really jumped out as being different guidance, important guidance on how we interpret Bostock in a couple of areas. And one was the question of bathroom usage. Do employees have a right to use whichever bathroom they associate with based on their gender identity and sexual orientation? Or the other one was the pronoun usage piece that was in the anti-harassment guidance. And that pronoun piece basically said that if you refuse to use someone's preferred pronoun, that can be discrimination or harassment. And those two issues are called out by the EEOC in this most recent press release as being in the crosshairs. So under the current EEOC, that is being challenged as to whether or not that anti-harassment guidance is still good and is still solid for employers to follow. So to me, the big takeaway here for employers is this is an issue you need to be watching. Clearly, there is, under the new administration, differing philosophy attempting, as it says in plain terms here, to roll back prior advancements under the Biden administration that relate to gender identity and the Biden administration's gender identity agenda. So although we don't have any concrete takeaways right now to tell you exactly what's going to happen in the coming months, the big takeaway is you need to be watching those issues at least, because there could be some type of change in how Title VII is interpreted, how Bostock's interpreted, and what happens with that EEOC guidance. So one issue to be watching out for. The other one we wanted to highlight for you is the executive order 14173 that was issued by the new administration, and it was entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. We have heard a little bit about that one over the past couple weeks, and it appears to be, according to the EEOC, aimed at protecting against national origin discrimination. And according to the EEOC, it indicates they're going after policies and practices that prefer illegal aliens, migrant workers, visa holders, or legal immigrants, anything preferring folks who fit in those categories over Americans. So that is definitely something different that we have not really seen the EEOC categorize as a priority. And so I think it's worth having a little discussion about what that could mean and what that could look like for employers as well. Doug, Jennifer, anybody have thoughts on that one?
The thing that really strikes me about this, there's a press release from the EEOC from the 19th of February, and it says in it that the EEOC will help deter illegal immigration and reduce the abuse of illegal immigration programs by increased enforcement of employment anti-discrimination laws. So this seems to be a big change here, because the fact that the EEOC has kind of combating illegal immigration as a goal at all, it seems to me to be very different to how they've operated in the past. And I guess I'm not really sure like why or how they can do that as their goal. Like that's not their goal. Their goal is to enforce the discrimination laws. Now, I guess they're saying that by doing that, they will be helping deter illegal immigration. But I guess that just kind of confuses me a little bit. So.
Yeah, and I guess where my thoughts went when I was looking at the same press release that Doug just mentioned, there are some places there where the EEOC refers to prior efforts to protect, American workers from discrimination. And if you go look, there are examples of cases in the past, particularly in workplaces where, an American-born worker may be in the minority of the employees. And the EEOC did have an enforcement action to say that was discriminatory, whatever happened. So it has happened in the past. What really seems to be the biggest change here is that it's become an enforcement priority. And the other puzzle piece, I guess, to keep an eye on relating to this is that there currently is a case in front of the U.S. Supreme Court that just was argued. The case is Ames v. Ohio Department of Youth Services. And the issue there is the standard for showing discrimination if you are a member of a majority group. So historically, if you are, say, an American employee, you are part of a majority group. And if you were going to show discrimination, you would have to meet a heightened standard, right? You have to show more in order to show that you were discriminated against under Title VII. And the case in front of the Supreme Court right now poses the question whether or not that is or should be the law and what that will look like going forward. And this will have potentially a lot of impact on what are quote unquote reverse discrimination cases, which I think prior to this newest announcement from the EEOC, a lot of listeners and a lot of us even here would have thought about a case being brought by an American worker as a reverse discrimination case. So that's also something that's happening in another branch of government, just to keep an eye on, because it really could affect how easy or difficult it is to bring these kinds of claims at the same time that the EEOC is welcoming them and making them an enforcement priority, it appears.
Yeah, I think that is one of the big things to be watching for is, whether claims as we traditionally have seen them change altogether. I know that over the years here, we've had a few reverse discrimination claims that we've defended against, but definitely has not been a big source of claims. So, one thing that jumped out to me is we're thinking about employers and what they do with these EEOC priorities and changes. What do you do with those? What are the best practices for employers right now in the state of flux, right? And what type of things should you be thinking about and watching out for? That's always one thing we're aiming to do here is we know you're tuning in. We want you to have hopefully a good practical tip you can take back with you. One thing that jumps out at me, and we have noticed over the last few years, for sure, probably not a new issue, but thinking about the role that disrespect and maybe unprofessional conduct might have in your workplace has always been a problem, right? We know that that's always been something flagged by the EEOC is when you have a culture that's maybe toxic, has groups that can't get along with each other, maybe has several people who can't get along with each other. We know that that type of conduct, if it goes unchecked, can definitely lead to claims and lawsuits. I would say that this new guidance from the EEOC, particularly the one that's referencing an EEOC attempt to protect Americans from anti-American bias, I would say that that one flags an even higher priority that employers should take to make sure they are not letting conflict and tension in the workplace get out of hand, especially if you have, for example, maybe a group of, I'm going to use an example from a client we had a couple years back. We had a client who had a group of Hispanic employees. That group was tightly connected. They would interact with each other not only at work, but after work. And then there was a group of white male employees who were from the United States who believed that they couldn't get along with that other group from another country who had different cultural norms and, a different social behavior. In prior times, I don't know that that would have really signaled to me as a high risk for a claim. But now seeing what the EEOC is coming out with, any type of disconnect and cultural clash and disconnect in the workplace, I would say you should be escalated to a higher place at this point because that may well draw claims, could be, from a number of different people. But that is not the scenario that I would have necessarily identified before this guidance came out as being at high risk for a national origin claim, certainly. So making sure that you're doing whatever you need to do to fix cultural disconnects and preventing exclusion, disrespect, incivility, those type of things, I would say, are going to be more of a priority than ever.
Yeah, I mean, employers really need to be plugged into not just the productivity of their workers, but how they're getting along and what's actually going on in the workplace. I think that's something we hammer over and over again, and this really highlights it.
Yeah, and maybe even, manufacturing sector, construction sector, probably not a huge shock. Those have always been identified by the EEOC as industries that maybe are at higher risk of discrimination or harassment. But I would say now, maybe even more than ever, special care should be given to get a good culture going where you can eliminate possible claims of that could fall into this new category.
Yeah, that's history as well. I think that's a big one here too.
Good point. Yeah.
Well, I was just going to add, you hear us, I think, a lot talk about the importance of training. And if you have, as a workplace, have not done, say, a respectful workplace or anti-harassment, anti-discrimination training recently, now would be a good time to consider doing that.
Yeah, and maybe analyze, how effective is your program? Because I will say that firsthand, I've had a number of clients when I ask, are you getting training? They'll say yes, but it's online, it's virtual, it's a check the box. Nobody's really paying attention. I mean, I don't know that just going through the motions will save you on this one. I mean, make sure it's something that you can actually use to get through to folks and, get some dialogue going in some way that's effective. So another issue, maybe our last one, since we're bumping up on our time here. But one other thing I wanted to mention, in addition to training, is I would say now even more than ever, stay on top of what's going on, because we have seen so many changes in such a short period of time. You've heard us talk about how 2024 had all these changes. Well, that's like nothing compared to what we've seen so far in 2025. And some of these are very significant, very big changes that alter the way the law could be interpreted and enforced. As of yet, we haven't seen the law itself change, but the enforcement agency is certainly indicating it's going to change the way the law is enforced. So people need to be paying attention to see what that means. We are here in Idaho, and we now have so many conflicting pieces of legal guidance that if you're an employer, that's going to make it challenging trying to figure out what is the binding piece of legal guidance you need to be following here. We have our Idaho Human Rights Act, we have Title VII, but then we also have some state law that has, in some respects, some conflicting language in it. And a couple months ago, I would have said you could look at the EEOC guidance and it would be in line with the federal law, but not so much today if you go by what the EEOC itself is saying, because the EEOC is now saying we're going to walk back some of what we put out last summer in regards to anti-harassment guidance. So super important to keep an eye out for changes, and a great resource. I know a lot of you are members and tune into it, but SHRM, I would say it's blown my mind how much info SHRM, the Society of Human Resource Managers, is kicking out right now, really on a weekly basis, working very hard to keep employers updated. They're kicking out email blasts. That's a relatively inexpensive way that you can get real-time updates on some of these things that will definitely help point you in the right direction for compliance. Jen and Doug, anything else on?
Yeah, I just wanted to flag something we were talking about before the episode, is that employers that are operating in multiple states will have an added complication. The law, we're in Idaho here, and the laws in neighboring states look a lot different than they do here. And maybe even if our laws in Idaho may not conflict with what we will see in the future, they may conflict in those states. So get as much information as you can and keep your eyes.
Yeah, that is an excellent point. We work with a fair number of employers who have operations in Washington, Oregon, And we know those states have some additional layers of state law protections that may well have been more in line with the EEOC guidance that the EEOC is now saying they believe is incorrect, and they're going to walk it back. So many potential layers of conflict in the law that you should be following that you really just need to keep your eyes open, have some type of reliable source of information coming across your desk so you're getting info as it becomes available.
The last thing I was going to throw on there is probably now more than ever, if you have a situation arise in your workplace that touches on these issues, you probably are going to want to get some help working through it, because even if you're staying on top of everything, I maybe am not alone in feeling like it's a bit of information overload right now, because there are so many things going on, and even new court cases being brought every day challenging various aspects of what is happening. And some are going places and some are not. So at any given time, on any given day, it's probably going to be a good idea to really drill down into what the specific issue is and do a thoughtful evaluation of what the lay of the land is or what it could look like. Because even staying on top of the generalities, while a really great idea, you're probably going to want to do it just a little bit more if you actually have an issue come up in the workplace specific to that issue.
Yep. Okay. That covers our EEOC update session today. Just a couple reminders. One is that we have our book available now, our Law for Leaders, the roadmap every leader needs to follow to avoid workplace claims and lawsuits. Does it cover this exact issue? No, because it came out in January and the law has already changed. But I will tell you, there are probably 12 other chapters in the book that track the law, and that law has not changed. So still a great resource. And then we also have our Law for Leaders training that we can do custom training. If you're hearing any of this and it resonates with you, that you definitely need to get someone in to train your workforce, keep us in mind, because we've got virtual content, live content, and we can customize it for whatever you need. So that's it for today. Thanks for joining us on Ground Rules, and we'll see you next time. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.